We have there's something called the doctrine of stare decisis. I'm not sure if I'm saying that right, but and what basically we're going to go into depth on what is stare decisis. Basically, if you look at the centuries-old legal principle stating that judges should defer to past interpretations of statutes in the Constitution, it comes from basically the term stare decisis comes from a Latin expression, stare decisis, um, et non quieta movere. I'm not sure if I'm saying that right either. Um, it means to stand by things decided and not disturb the calm. Now, erring on the side of upholding a precedent makes the law seem ever-handed and predictable, or even-handed, sorry, and predictable. This is what the then Chief Justice William Rehnquist had wrote back in 1984. Supreme Court Justice Lois Brandeis had gone further back in 1932, writing that in most matters it is more important that the applicable rule of law be settled than that it be settled right. Periodically throughout the U.S., about 232 times to be precise, Supreme Court justices have disregarded stare decisis and overruled their predecessors. A 5-4 conservative majority appears poised to do that with Roe v. Wade, and Justice Samuel Alito devotes a substantial chunk of his leaked draft opinion to arguing why Roe was egregiously wrong from the start and thus unworthy of the stare decisis. Whenever a majority of Supreme Court justices feel like it, some legal scholars argue that a select group of old landmark cases should be considered irreversible super precedent. But the court has observed repeatedly that stare decisis is not what they call an inexorable command. In a 2020 opinion, the Supreme Court Justice Rapist Brett Kavanaugh had mapped a 7-pronged test for applying stare decisis: the quality of the precedent's reasoning, and the precedent's consistency with other decisions, changes in law since, changes in fact since the decision's workability, the degree to which people have come to rely on it, and the precedent's age. Now, nearly everyone agrees that, at least in theory, that it's not sufficient for new justices to personally disagree with earlier rulings on ideological grounds. Now, in 2018, five conservative judges ruled that the First Amendment protects public sector employees from being forced to pay union dues if they're not members. Now, the Supreme Court Justice Elena Kagan had accused the majority of overruling a 1977 precedent for no exceptional or special reason, but because they never liked the decision to begin with. Now what's going to be overturned and what's been overturned so far? Some of the Supreme Court's most momentous decisions had rejected precedent. Perhaps most famously, back in 1954, Brown v. Board of Education had ended the racial segregation in public schools, overturning the separate they overturned the separate but equal doctrine that was established in 1896, Plessy v. Ferguson ruling. In 1976, the court ruled that Georgia's administration of the death penalty didn't violate the Eighth Amendment's prohibitions against cruel and unusual punishment, and validated a decision from just 5 years earlier. More recently, back in 2003, the court deemed laws banning sodomy and gay sex to be unconstitutional, reversing their 1986 decision. Back in 2015, basically in 2015, the 2015 identified a right to same-sex marriage, overturning a one-sentence ruling back from 1972. The 2010 decision in Citizens United v. FEC strikes down limits on corporate campaign spending, overturned 2 decisions, one that was recent as of 2003, but when the court upheld Trump's travel ban back in 2018, Chief Justice John Roberts went out of his way to disown the infamous 1944 decision. In the 1944 decision in Korematsu v. United States, which let stand the internment of Japanese Americans during World War II. Korematsu was gravely wrong, Roberts wrote, and it has no place in law under our Constitution. Legal scholars like to joke that stare decisis is Latin for stand by things decided when it suits our purposes, even though that's not what it stands for. Every justice claims to respect stare decisis, but both Democrats and conservatives have attacked their rivals for abandoning precedent when ideologically convenient. The ultra-Democrat Warren Court overturned up to 4 precedents per term. Roberts frequently expounds on the importance of stare decisis, but since 2005, he has voted with the majority of about 3/4 of the time on rulings that overturned precedent. Now, the die-hard Republican Supreme Court Justice Clarence Thomas is leading the charge to discount the stare decisis, saying that the court should not be bound by demonstrably incorrect previous rulings. We use stare decisis as a mantra when we don't want to think, he said. Well, that's the thing about the Republicans, they don't think. Now, Democrat court watchers say Alito's leaked opinion is a blueprint for gutting other privacy-related rights. In his draft, Alito says that Roe and Planned Parenthood versus Casey, which was the 1992 case affirming the central holding of Roe, has to be, basically he claims it has to be overturned because there's no right to privacy or abortion in the Constitution, and that implicit rights must be deeply rooted in this nation's history. Now, previous courts had cited a right to privacy as the constitutional basis for protecting access to contraception, legalizing gay sex and same-sex marriage and other rights that are now in the conservative movement's crosshairs. Now, Alito insists that overturning Roe does not threaten precedents, but they do not concern abortion. His assurance is hardly binding. 2 years ago, he and Thomas complained in an opinion. They complained in an opinion that the court had created a novel constitutional right in same-sex marriage that was ruinous to liberty, or religious liberty. The court, they said, has created a problem that only it can fix. I doubt that. Trump's high court nominees, the rapist Brett Kavanaugh, Neil Gorsuch, and Amy Coney Barrett, reportedly all plan to join Alito and Thomas in overturning Roe. The news drew outrage from senators such as Republican Susan Collins of Maine, who said their vote would be completely inconsistent with that Gorsuch and the rapist Kavanaugh in particular said during the confirmation hearings. Conservatives, however, say the future justices choose their words carefully. Gorsuch told the Senate that Roe has been reaffirmed, adding, a good judge would treat it like any other precedent. Yeah, I doubt that. Except the law of the land, he testified. The rapist Kavanaugh called the case an important precedent of the Supreme Court and has been reaffirmed many times. Coney Barrett, whose personal opposition as a Catholic, she's a fake Catholic, she's not really Catholic at all, but to abortion drew intense scrutiny during her confirmation. She declined to call the right to an abortion a super precedent, saying that we're answering a lot of questions about Roe, which I think indicates that Roe doesn't fall into that category. After Alito's draft leaked, Senator Tim Kaine, who's a Democrat from Virginia, said justice is looking at you in the face and telling you one thing and then doing something different. This is very fucking troubling. So if you like the video, give the video a like and subscribe to my channel, RBW King. You can also hit the notification bell so that you'll be notified when a new video comes out. And if you want to support my work even further, you can donate to my Patreon link, which you can find in the About section of YouTube, and just for as little as a few bucks a month. You can help the channel go a long way, and thanks for listening.